idea what happened, but I want to find out. You have the right to remain silent. Anything you say can or will be used against you. No,
Well,
not you. That you have the right to remain silent. Exercise that.
On March 29, 2025, law enforcement officers were on patrol when they observed a white Honda Accord driving south on a public city street located in Harris County. The law enforcement officer ran the vehicle's license plate through NTIC and activated their emergency equipment and followed the defendant's vehicle that drove into a gas station parking lot and pulled over to stop. The law enforcement officer approached the defendant's vehicle and observed the passenger sitting in the front seat wearing a seatbelt. The defendant requested the full name and date of birth of the passenger, who identified herself as Stephanie Avalar, and that was confirmed by the law enforcement officers. The law enforcement officer also found that that her name came back as a protected person from a recent violence incident, and ran the identifying information of the driver, also known as the defendant, that came back under the same protective order as the defendant for that case as well. The law enforcement officers reapproached the vehicle and detained the defendant, and confirmed that one of the law conditions and the protective order was the defendant shall have no contact with the
So it's just the right virtue of the, so we had issued the no contact, right?
Yes, Judge.
All right, so Mr. Avilar, I'm going to find if there's sufficient probable cause to go forward.
And this is where the judge drives the point home. Court orders aren't optional. They're like hard rules in a high-stakes game. If you want something changed, you don't freelance it. You go through your lawyer. The moment a defendant takes matters into their own hands, the system interprets it as disrespect. It's less about what you want and more about how you go about it. Think of it like trying to change the rules of chess mid-game. The court doesn't bend. It pushes back harder. Would you risk breaking a no-contact order just to talk to someone you love? Or would you play it safe through the legal channels?
That when we have court orders, we mean it. It's not hard. You have a lawyer. When you want something changed, you talk to the lawyer. The lawyer can come to us and we hear things out and we can change things. But when you try to do stuff on your own, everything goes sideways, and it goes sideways quick, as you now know. So,
in Your Honor, we will be, we'd like to approach off docket tomorrow to try to have the MOAP amended. The state did in fact try to call the CW, but they have not been able to speak with her to clarify that she would in fact like him to be able to come home and have contact and the like.
so what happened? Is
So
he,
terrorism threat, he appeared in PC court on February 13th. He received a PR bond, and
Right.
next week he came in here for an arraignment. He appeared. He got a reset for April 23rd.
right, but I'm showing now he's bond active after the new case. Why? Did they give him another PR bond?
No, this case was never.
Look, it shows bond made on the terroristic threat.
That's from the previous PR bond. He was never revoked after since the new case. This case has still been on bond.
Did they not address it? And I'm at a loss if they never addressed it.
Yes.
It was new court. His only reset is for April 23rd.
Mr. Woodward, my concern is that, they gave them a PR bond on the terroristic threat. I don't even show that a PR bond was given. Oh, here we go. On 2/13, now he's picked up a violation of protective order. So I can't continue to give you a PR bond when you're picking up new cases, man.
Can I speak? Can I ask? It's because I made bond.
No.
Sorry.
You need to talk to your lawyer before you talk to me, because I don't want you to say something that hurts your case,
Sir.
I'll give you time to talk to him, but I can't, we do things a certain way. You can't do stuff on your own. You've been through the system long enough to know that,
Yes, sir.
Are you on parole at this time?
No, sir, I'm not on parole, but I paid for my bond.
Hold on. So no PR bond on the terroristic threat. Okay, let's do this. Your lawyer said he can be here tomorrow. So we'll have him come here tomorrow so he can talk to you and you guys can regroup, try to figure something out. So Mr. Woodward, you say you can be here tomorrow?
Absolutely.
You want to address it, I guess, then?
Yes.
Okay, so we'll roll you to tomorrow. We'll try to figure something out.
Judge, he's supposed to get released today because of surety bond on the BPO.
Rep, I'm not giving him another PR bond when he picked up a VPO though.
Do you want me to revoke
The PR bond,
the-
yeah,
No,
Your Honor,
yeah.
I mean, I certainly understand how you work, but since I'm not there with my client, I just like for him to experience that. The facts of the underlying case, Your Honor, are that, he and the CW, they're in a relationship. They had an argument. She grabbed his hair first, was pulling him, then he was grabbing her, but a text message was sent from an unknown number saying, if you don't come home, I'm gonna fuck you up. Excuse my English, Your Honor, but that's what was the crux of the PC, Your Honor.
Of which one?
For the terroristic threat case.
I don't know. I guess what happened in the terrorist threat?
Yes, Your Honor, if I just have one moment.
My understanding is that the CW is willing to communicate, that there was a little bit of a misunderstanding of the facts. I believe the state called her once. She said she wasn't available, but she would be if they called back. I don't think that she's been able to communicate that there was a little bit of a misunderstanding of the facts.
Your Honor, what I have is that this was the threat was made during an altercation where the defendant told the complaining witness, and I quote here, I apologize for the language.
Don't be shy. Come on. We all know the F word.
I'm going to fuck you up if you don't come home.
I understand that was made during an altercation, Your
If you
Honor.
don't come home. It was made during, the defendant admitted that there was an altercation, admitted that he told the complaining witness, I'm going to fuck you up if you don't come home.
Your Honor, I'm looking right at the summary of facts. It literally says, on her cell phone contacts, complainant stated the defendant then began to threaten her via cell phone text, which he stated, I'm gonna go kick your door. I got you. I'm gonna fucking kill you. Complainant stated she was fearful for her safety. But before that line, it says they came from an unknown number. It says it in the summary.
Your Honor, it is further down in the summary of facts that there is an admission.
I mean, of course, Mr. Woodward, someone can make something from an unknown number, but they can corroborate it at the same time, And I think that that's
Yes.
what the state is saying here, that he corroborates the actual text message.
This is the breaking point. The judge lays it out crystal clear. PR bonds aren't bottomless chances. Each violation makes the system lose faith in the defendant, and eventually, the court has to show teeth. It's not even about the original charge anymore. It's about whether the defendant respects authority. Bond hearings may seem procedural, but they often decide the tone for the entire case. Respect the rules and you get breathing room. Ignore them, and the judge makes sure you learn the hard way. Honestly, do you think this defendant should still get PR bond privileges after stacking up violations?
That I'm going to go fuck you up. Right?
Yes, Your Honor.
Yes.
The problem is that we have him, he's still doing stuff on his own. I've told him not to do it, admonished him not to do it, and he's still,
Yes, sir.
in this life, when you do things the right way, good things happen. When you do stuff the way you want to do it in violation of orders, and you've been through this sufficient that Now, it's not the end of the world, but how do I get your attention so that you realize that we mean business? If I just give you PR bond after PR bond after PR bond, I mean, we have no teeth.
yes, sir. I paid out of my pocket to get bonded. They gave me a bond downstairs and I paid for
When
it.
you're on your VPO, but I'm not going to give you a PR bond when you're picking up a VPO.
She called me, her home had it.
I'm not going to, no.
Alright.
Like I said, talk to your lawyer first.
Yeah.
Before you start telling us stuff, because I don't want you to put
Yes,
your
sir.
in your mouth when you think you're trying to help regardless. Now, look, we can come back tomorrow. He's going to come here. We can try to work something out. But
I was just trying to help, sir. I've been staying away from her. I got like 10 days left.
Sir, I got you. I'll come check up on you, okay?
back tomorrow, we'll deal with it and we'll figure something out. So you'll definitely be here tomorrow, Mr. Woodward?
Absolutely, Your Honor.
Okay, so I'm gonna revoke it for now. Come back tomorrow, we'll talk. Do you have a place so they can reach out to the complaining witness so they can get a rip done by tomorrow? Mr. Woodward?
I do not have it readily available, Your Honor. I can likely get it.
Okay, so don't, I mean, can you try to do a rip between now and tomorrow? So we can try to figure out what she wants and then we'll go forward, please. Okay, all right, we'll see you tomorrow.
Thank you, Your Honor.
All right, bud. We'll see. Good morning, Ms. Dews. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On March 18th, 2025, at 5:21 p.m., an officer was dispatched to a theft at Walmart with a female in custody. Upon arrival, the officer took custody of the female identified by her Texas driver's license. The officer searched the defendant before passing custody over to another officer. That officer spoke to the loss prevention officer who stated he was following the defendant in the store and observed her concealing items in her purse and backpack. This was done in a blind spot of the cameras, so they were not videos. The defendant then continued shopping before checking out and paying for some items. The defendant did not pay for the items she had concealed in the bags and passed all points of sale before the loss prevention officer stopped her. The defendant admitted to stealing before turning the items back over. The total value of the items was $120.86.
Got it. Thank you. Ms. Dews, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any Walmart for any reason whatsoever. If I find that you do, I will revoke your bond, put you in jail, and no more PR bonds for you. Do you understand?
Yes,
Likewise, if I find that you put any new cases, your bond will be revoked. You will go into custody, man. Do you have the ability to hire a lawyer? Okay, I will have you fill out an application. Deputy Miranda is going to give you an application. I'm going to have you sign a receipt with Victoria. After that, we'll have you take a seat in the jury box while we get your bond conditions ready. Do not leave until you sign them. Okay, please. Do you mind filing those? No going to any Walmart,
Yes, Your Honor.
anywhere,
No Walmarts anywhere.
anywhere.
Thank you, Your Honor.
Frank Reyes.
Yes, sir.
Mr. Reyes, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Simply. Okay.
Officer was dispatched to a minor crash in Harris County, Texas, where the defendant had rear-ended the complaining witness. Upon contact, the officer found the defendant in the driver's seat, slipping in and out of consciousness. When the officer woke the defendant up, the defendant attempted to start his car and drive away, but at that point, officers had his keys. The officers did not notice any injuries on the defendant. When the defendant exited the car, he was unsteady, and officers observed and uttered alcoholic beverages, bloodshot eyes, and slurred speech. The defendant admitted to drinking at a bar earlier. Standardized foot sobriety tests were conducted, and the officers observed 6 out of 6 on the HGN, 8 out of 8 on the walk and turn, and 4 out of 4 on the one-leg stand. En route to the joint processing.
Now we pivot to a new case, but the theme remains: respect the court or lose your freedom. Here, a theft charge at Walmart may sound minor compared to threats or violence, but the judge treats it just as seriously. Why? Because bond conditions apply across the board. Once you're on the court's radar, every slip is magnified. Notice how the judge bans Walmart outright. It's not just about punishing theft, it's about preventing temptation. Think about it. Should judges go this far, banning people from entire stores, or is that overstepping?
Center, the defendant fell asleep in the officer's vehicle. At the joint processing center, officer read the DIC and defendant consented. However, the defendant fell asleep again and began vomiting. The defendant was transported to the hospital, and a blood warrant was signed and executed.
So no breath test was done.
No, Your Honor.
Mr. Can you run his license, please? See if he has a valid license.
Yes, Your Honor.
Mr. Reyes, I'm going to find that there's sufficient probable cause to go forward with your case. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not, I'm going to give you a portable device. You're not allowed to drive any vehicle from now on that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock on it, I'm going to put you in jail and I'm going to make your bond high. Do you understand?
I understand.
It says ineligible, Your Honor.
You are not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive. Mr. Reyes, heed this warning. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car and drive. Do you understand?
I
You
understand.
cannot justify driving for any reason. I don't care if there's a burning building and you have to save 50 babies. Do you understand?
Mhm.
I'm sending notice now to DPS so that every single officer in the state knows that you are not allowed to drive a vehicle that doesn't have an interlock. If you're caught driving a vehicle, it doesn't have an interlock, they will arrest you and put you in jail. I am now giving you a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. You will also be tested for illegal drugs as well. You test positive, you consume alcohol, into jail you will go. You have the ability to hire lawyers, sir.
I do.
We're going to give you time. I'm going to have you come up here, swear to us that you're not going to drive. I'll get you to Victoria. We'll have you sign a reset. You will get with Felicia for your bond conditions, and after that, you're free to go.
Please, I'm so offended.
Good morning, Mr. Sullivan. Sir, you were charged with assault with a family member. You're facing up to a year in jail and a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On March 23rd, 2025, at approximately 15:39 hours, the law enforcement officer was dispatched to an address in Harris County, Texas. In reference to a disturbance. The law enforcement officer arrived on scene. They made contact with a witness who stated that her husband, the defendant, had been arguing because her adult daughter does not like the defendant and asked the complaining witness to pick between having a relationship with her and her grandchildren or the defendant. The complaining witness stated she decided to sever a relationship with her daughter and informed the defendant that she would be moving back to Arizona. The complaining witness stated this upset the defendant and he began arguing with her. She then expressed that she hated him and this made the defendant more upset and he told her to hit him if she hated him so much. The complaining witness stated she hit Mr. Sullivan with a closed fist on the head and face area 3 times before losing balance, slipping and falling. This fall caused her to hit her face on their bedroom dresser. The complainant then said she got up and crawled into bed, and she was laying on the furthest corner of the bed closest to the wall and covered her body with a blanket. The complainant witness said that approximately 10 minutes went by. Mr. Sullivan, the defendant, continued to argue with her. He crawled on bed, grabbed her, flipped her over, her back was on the mattress, and used his body weight and then on top of her while placing both hands on her upper arms to hold her down. The complainant said this caused her pain, and she was able to free one of her arms and use her hand to grab the defendant's genital area and making him let go of her completely. The defendant then used his right hand and punched the complaining witness on her mouth, causing pain and visible injury. The complaining witness added the fight then diminished, is that the law enforcement officer observed visible injuries, including large purple bruises on both arms and injuries to the top and bottom inner lip.
Laser, you hearing this?
Yes, Your Honor.
Interesting. So she's the initial aggressor though, correct?
Your Honor,
So it looks like he says, hey, hit me, antagonizing. She gets into it. She pops him, what, 3 times in the mouth, you say?
Yes, Your Honor.
No, don't say anything. Sorry.
So, Your Honor, only thing I would ask is, this is not home court's case. If we can just stand down, wait for the DVD prosecutor to be here. I don't know if he's spoken with the complainant yet, if he has anything more to add. I would just ask the court to withhold the finding until we can get the prosecutor.
All right, Mr. Sullivan, just do me a favor. Will you just take a seat in the jury box? I'm going to get, I'm going to also appoint him a lawyer, if you don't mind. I'm going to appoint him someone as well so we can do just.
That's totally fine, Your Honor. Let me, and I'll email DVDs.
Okay, all right.
Thank you.
Do me a favor, just take a seat for me real quick, all right?
All right, Judge, next is.
You're Abner Guzman.
Guzman. Yes.
Mr. Guzman, you're charged with displaying a fictitious license plate.
Golden red flag asking.
6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you. On March 24th, 2025, at around 11:20 a.m., officers were dispatched to a B&B call at 2520 Airline Drive in Harris County, Texas.
Upon arrival,
Al llegar,
officers
los
observed
oficiales
defendants
observaron el acusado,
vehicle parked in the west side
que
parking
había
lot
estacionado en un lote de estacionamiento
near the fence of the
cerca de
Houston
la cerca
Farmers
del
Market,
Houston Farmers Market,
with the front passenger window
con
broken.
la ventanilla del pasajero del frente quebrada.
Officers
Los
conducted a vehicle
oficiales
check
hicieron un registro de vehículo
on the temp license
en la
plate
licencia de manejar temporal,
and returned it
pero
without
la
match
placa, y regresó, lo tenía ahí,
the defendant's vehicle.
del acusado, el vehículo del acusado. Perdón.
At 12
A
p.m.,
las 12 p.m.,
the defendant arrived
el
on
acusado
scene,
llegó,
told officers that he was the owner of
le
the
dijo al oficial que
vehicle.
era el dueño del vehículo.
Defendant was
El
detained.
acusado fue detenido.
Defendant said he had purchased the
Luego
vehicle
compró el vehículo
5 years prior
5 años anterior
in Florida
en la Florida.
and paid an additional fee for the seller
Costas adicionales al vendedor
to change the
para
title
que
to
le
his name.
cambiara el título,
But the seller did not do that.
pero el vendedor no lo hizo.
Defendant stated he met a
El
woman
acusado declaró que él conoció a una mujer
on WhatsApp
en WhatsApp
who offered him a
que
fake
le
temporary license
ofreció
plate
una placa falsa temporal
for $40,
por $40
which he purchased.
que él compró.
Defendant stated he had
El
been
acusado
driving the
dijo que había
vehicle
estado manejando el vehículo
with fake temporary
con
license
las
plate
placas temporales falsas
for 4 years.
por 4 años.
The defendant was
El
ID'd by his
acusado fue
Guatemalan passport.
identificado por el pasaporte de Guatemala.
Mr. Guzman, I'm going to find that there's sufficient
Que hay
probable cause to go
suficiente
forward.
causa para seguir hacia adelante con su caso.
If you do not have a Texas
Si
driver
usted no tiene
license
licencia de
and
manejar en
liability
Texas,
insurance in your
el
name,
seguro,
you are not allowed
su
to
nombre
drive.
no se le
I
permite
don't
manejar.
care what you need
A
to
mí
do in
no
this
me
life.
importa qué tienes que
If
hacer
you're not
con
properly
esto. Si
licensed
usted no tiene
and have
licencia
insurance,
española y tiene seguro de carro,
not
no
drive.
maneje.
You'll be signing a promise with me. This is an affidavit that you're going to swear to me that you're not going to
Claro
drive.
que usted no va a
You
manejar
cannot justify driving for any reason.
manejar
If I
por
find that you do, I will revoke your bond and put you in jail.
finanza, le pongo
I don't know what
cárcel.
your immigration status
Pero
is,
si está
but if you're not in this country with permission
en este
and you go to jail,
a la cárcel,
and immigration finds you,
encuentra
they
el
will put a
migrante,
detainer on you and you will be stuck like Chuck in there until this case is over with,
caso se
and then you
acabe.
get shipped off to immigration. Do you understand?
Entiende.
Sí.
Yes.
Do not.
No maneje.
This is the only bond condition that you have. Do not pick up any new cases as well. If I find that you're a danger to my community, likewise, I will put you in jail.
Igualmente no.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with him. If he tells me that he cannot get a hold of you because you're playing games, you're not responding to phone calls, text messages, likewise, I will revoke your bond. Do you understand?
Lo entiende. Yes.
Okay. I'll have you sign a receipt of Victoria. We'll have you swear to us that you're not going to drive, and after that, you're free to go.
Thank you, Judge. Maybe excuse me. Thank you.
Yeah, take care. Hey,
Aaron Durden, bond violation report. You said bring him today. He's here.
come up, Mr. Durden. We're here on yet another bond violation report. It is now alleged that the client was instructed to install an ignition interlock device, not to tamper with the device, to blow into it. And from 2/20 to 3/20/25, you skipped 8 tests, not using the device as instructed.
I'll explain, Judge.
Please.
All those violations except one are on the same day. If you look at the photos, the person there's only one person in any of the photos. It's not him. He owns a company. He allowed his employees to drive the truck. They didn't understand the deal. All the other pictures show nobody in the truck. What they did, they're roofers. They just left the truck running while they were doing work to keep the climate control on. He has since clarified that. We've emailed pretrial last week asking them to try to get the photos before the violation so we could see who was actually driving the truck, but we didn't hear any response.
He has guys, does he have a blow schedule that he's supposed to blow? He has a blow schedule. He's supposed to blow at certain times and he's not blowing.
Are you not blowing at certain times?
That's not, no, that's not true, Your Honor.
I have here 8 skip tests.
No. So one of my guys was driving the truck and he did not, I didn't instruct him that when you stop the vehicle, that you can't just leave it running. So he was wasn't informed about that, so he just left the
Yeah,
truck.
but it was rolling retests that were skipped. That's the allegation, rolling retests. So somebody started the truck, got out of the truck and left it running, and it just kept saying blow, blow, blow. If you look at the times and date, they're like 5 minutes apart for 15 or 20 minutes.
Yes, Judge, I do see that it's the rolling retest. As far as what specifically that entails, honestly, that's something I haven't encountered before.
I haven't either, but
Yeah.
bottom line, he's supposed to test at certain times.
Yes, but that would be a missing test, but the allegation is in the bond violation of rolling retest.
So yes, there's no violation, no allegation that he has missed his flow schedule.
What times, do you have this time set that he's supposed to actually blow?
I can reach out to the manager and get that information.
Do you mind? I'd like to know what specific times is he supposed to test?
Yes.
And did he actually do it on that times, or is it someone else blowing? That's what I'd like. So let me see what they say and then we'll come back.
Judge, I have Odiambo on today's docket. He's doing the DWI-PTI program. He just needs a little more time to get the device.
Last name is
Marina Odiambo. It's hyphenated. She's been having some financial issues, and so he's trying to get some money together to get the alcohol monitoring device. And we also need to submit the industry affidavit, but he's provided that to me to get the
213 days old.
Just we can get 2 weeks just for him to get the device. That's all we need. We have the contract already, and we just need to get the fee waived as well.
Bring him up.
Yes, Judge. I'm just trying to get this wrapped up, Judge, and we're really close.
So are you doing that for the fee, right, James?
Yes, Judge, we have to submit the device, or we have to submit the industry affidavit for the $300 fee, and then he also has to get the alcohol monitoring device.
Filled out the affidavit.
Judge, he has that filled out. It's just I need to get a PDF copy of it, and he says he can scan that to me.
You have everything now because we can scan it, bring him back and I can.
No, Judge, he took photos of it, and that's not gonna work for them.
Your case is 215 days old. I'm not giving you any more time. It's not, if you don't have it done, I'm going to immediately set you for trial or you're going to take a plea bargain agreement from the state. But I'm not giving you any more time after that. You need to have everything done by that time. You need to submit the affidavit today, not tomorrow, not next week, because they need time to review it to see if they're going to grant it for you. I will not give you any more time after this 2 weeks. If you don't have it done, I will bring you back day for day until you have it done. Do you understand? Okay.
Thank you, Judge.
That's
Can I get
final
2
2
weeks? Thank you, Judge.
I just got hired on Miss McKelvey. This is the one you emailed me about. She's in the box. Pretrial has indicated to me that she did take a test last Tuesday and she did test negative. She tried to go to Quest, which we sent her to. They wouldn't take it because they didn't have enough information. But she ended up testing, I guess, through pretrial.
Yes.
Okay.
When did you test last?
Tuesday.
Tuesday, Judge, the 25th of March.
Okay. Come up, Mr. McKelvey. I'll just admonish her now.
Thanks, Judge. I told her zero tolerance. I mean, she's a real sweet lady. I don't think you're going to have any issues with her in the future.
It's no tolerance. If you miss again, it's not going to go well. All I'm asking you to do is show up when they call you to take a test. You understand?
Yes, sir.
So right now, nothing's going to happen today. But if it happens again where you miss a test, then I will issue a warrant. No tolerance. You understand?
Yes,
You're
sir.
not to use any alcohol. You're not to use illegal drugs. And that's how we ensure that it doesn't happen. Understand?
Yes, sir.
Okay. All right.
Judge, may she sit in the audience? Thank you.
Good morning, Your Honor.
How are you?
I'm fine. I don't have any big problems today.
Something nice.
All I need is a reset for 45 days. The prosecution and I have come to an agreement. Christian Willis. The prosecution and I have come to an agreement as to the resolution of this case. He just needs about 30 days in order to.
It's nearly 200 days now. What did they offer?
We've offered a PTI now, Your Honor.
And what
So I spoke to the weapon and gun safety class and a drug and alcohol awareness class, I believe. And a drug awareness class, I believe.
So I'm gonna give him 2 weeks to get the stuff done.
2 weeks?
Yeah, it shouldn't take that long. It's a gun safety class, it's probably 2 hours.
Yes.
Then The other class also is just a couple hours.
So
So
can we do 3 weeks instead of 2? Because I still have a balance. 3 weeks. 3 weeks. Thank you, sir.
Mr. Willis, where's Mr. Willis?
He's out here.
Come up.
This is the first time ever getting in any.
Mr. Willis, he has secured you an amazing deal where if you do 2 simple classes, both of your cases will get dismissed. If you do not have if you don't have them done in 3 weeks, I'm not going to take anything else. I will immediately set your case for trial. Do you understand? There's no excuse why you can't get both classes done in 3 weeks. All right, Mr. Cashin.
Thank you, sir.
See you.
See you next.